Committee will come to order. Without objection, the chair is authorized to declare a recess at any time, and I hope we don't need it. We welcome everyone to today's hearing on government litigation and opportunities for reform. I'll now recognize myself for an opening statement. Today's hearing will address various aspects of government litigation that we believe merits reform. Our House Judiciary Committee is charged with safeguarding Americans' most fundamental rights. And through that lens, today's hearing is going to primarily focus on three topics: civil asset forfeiture, sue and settle tactics, and settlement slush funds. In recent times, here's the problem. Civil asset forfeiture has become a device for unjustified governmental takings. Federal and state laws allow law enforcement agencies to take personal property through civil proceedings under certain circumstances. The standards for government taking of property vary from state to state and sometimes differ from federal standards. The problem today is that current federal standards for civil forfeiture invite abuse, in part because state agencies can skirt state-based forfeiture protections and rely on more relaxed federal law to confiscate property, and that results in innocent citizens losing their property that the government simply pockets. Reform to federal law is necessary to restore the original intent of the law because it's an important one and better protect citizens' property. On the second issue, another area of reform relates to the so-called sue and settle tactics. Sue and settle can occur where pro-regulatory plaintiffs and willing government agencies circumvent federal law, namely the Administrative Procedure Act, while rewarding special interests that they favor. When a pro-regulatory plaintiff sues and then settles with an agency in ways that require certain types of rulemaking, the result is the plaintiff and agency can avoid public scrutiny and congressional oversight of the agreed-to policy. So the sue and settle tactics also can bind federal agencies to rulemaking that extends from one administration to the next. With reforms, we can better guard against this tactic and return transparency, because that's what the American people want and deserve, and congressional oversight to the agency rulemaking. And finally, the third issue, in this hearing, we're going to provide the opportunity to examine the use of settlement slush funds. That's a phrase that's thrown around, but it refers to cases where defendants settle lawsuits with government agencies, but instead of the government directing all settlement funds to the U.S. Treasury or to the injured parties, agencies have this habit now, and agencies instead require defendants to give the money to politically favored special interests that are disconnected entirely from the litigation in many cases. And these types of slush funds directed to support pet projects go to obviously the pet projects of an administration. They can amount to a form of executive branch spending that's not approved or even reviewed by Congress. This circumvents congressional oversight and the resulting accountability of the executive branch. So here too, of course, we believe that reform is desperately needed. So Congress is considering proposed legislation to address concerns with all these issues. And these proposals include, for example, the FAIR Act, H.R. 1525, the Sunshine for Regulatory Decrees and Settlements Act of 2023, that's H.R. 3446, and the Stop Settlement Slush Funds Act of 2023, that's H.R. 788. Government's unwarranted taking of private property and the administrative state's litigation tactics to game the system on rulemaking or to direct funds to politically favored causes are highly problematic. And our deepest concern is that they're pretty clearly a violation of our constitutional order. So we're here today to gain a better understanding of these issues and how possible reforms will help restore confidence in our government. We were talking here just a moment ago that the people's faith in our institutions is at an all-time low, and we have to fix this because it's difficult to maintain a republic if the people lose faith in those institutions. So with that, I thank all of our witnesses who appeared to testify before us today, and I look forward to a robust discussion on these really important issues. And I now recognize our ranking member, Ms. Scanlon, for her opening statement.
Thank you, Mr. Chairman, and thank you.